Yes.
My lord, I am waiting for response number 1 to 4.
Who is for the petitioner? Mr. Sabir.
Sabir.
What he has prayed for?
There is a private respondent also. I don't know whether it is some.
Impugn notice dated 4th issued by the respondent number 3. Where is the impugn notice? Page 31.
My lord.
Where is Mr. Sabir? None appears on behalf of the petitioner. Mr. Shivamandan, none advocate appearing for
1 to 4.
respondent number 1 to 4. For the interest of justice, case adjourned. Let the matter appear tomorrow.
My lord, let it be day after tomorrow.
Day after tomorrow.
Oblige, my lord.
Day after tomorrow on 2nd. Yes, next.
Who
Who is your senior?
I am for the respondent, state laws.
What is the order under challenge?
Convicted, concurrent finding, appeal was dismissed.
Under section?
324, 506, 504, and 342.
What is the sentence?
Sentence was 6 months each.
Is a government servant? Is a government servant? C. He or she? She. Yes, when he will available? Friday. Thursday, come on Thursday. So suffering for the petitioner. So suffering for the state. No. As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on Friday. Thursday क्या date है? Third July. ए मेरा लिस्ट लेंगे.
First, I am for the respondent, state laws.
Who is for the petitioner?
Ajit. So, conviction, appeal dismissed. Then the
Section. What is the section?
468, 471.
What is the punishment?
Punishment was first.
3 years and 10,000 rupees. ID 6 months. Yes, where is Ajit?
There was a direction last to serve a copy to the defective complaint.
De facto complaint for what?
Last occasion it was offered by the another court.
Who is the complainant here? Agriculture Department employee along with the
Department.
name of the complainant Sanjay Mistry. Not today. Come on, next.
Sir.
Not today.
I appear for the petitioner, my lord.
My lord, I am for the petitioner, my lord, in this matter, my lord.
Yeah.
This is my application. I am challenging the an order of the learned arbitrator under section 25A of the Arbitration Act, where the claimant has not filed their statement of claim within time. So 25A says that there should be dismissed. The arbitrator has not considered this prayer and they passed the order and allowed him to file a statement of claim, my lord.
So how the CO will apply?
Revision, civil revision from the order of the learned arbitrator. It was a application, my lord.
It has application.
It was an application filed by the claimant for extension of time to file statement of claim.
Correct.
I have opposed that application.
Hmm.
And my lord, due to various reasons, I have said that the reasons there is not sufficient cause as per the section 25A of the Act, my lord. No
Yes.
sufficient cause has been given. Rather, the fraud has been played upon the arbitrator by giving false evidence by that due to various reasons. My lord, first they have asked for, my lord, may I say, my lord, they have to file statement of claim on or before 6th of December to 2024, my lord.
Correct.
Thereafter, they did not file. Then after that, on 4th December, they have issued an email to the arbitrator.
Mr. Singhania, this is connected with the arbitration. Correct. I am taking the matter. Let the matter appear before the honorable single judge who is having the determination of the arbitration matters.
And in the meantime, if they want to file affidavit, my lord, they may file.
Not any order, only I am releasing. Let the matter appear before the honorable single judge.
My lord.
It is fine from the record. The petitioner has challenged the order passed by the London arbitrator, wherein the London arbitrator has extended the time to file the statement of claim. In view of the above, this court finds that this is connected with the arbitration proceeding. Thus, the matter is released from the list of this court and to place the same before the Honorable Court number 1.
I'm grateful.
Obliged, my lord.
Record the name of Mr. Dickens. Next.
I am appearing for the petitioner. This is an application, civil revisional application, challenging an order, allowing an application under section 151 filed on that very same day, without allowing any opportunity to the plaintiff petitioner to file any written objection.
Where is the impugn order you are appearing for? Where is the impugn order?
My lord, the impugned order is, my lord, in the certified copy annexed to the petition, my lord.
Page number 104.
Ah. Where is the application? 151 application.
But I have annexed it with the supplementary affidavit, my lord, which I have filed. It's not there on the previous occasion.
That has been filed pursuant to leave by the honorable court before the registry was. Today morning, Friday was one leave of the registry.
Supplementary affidavit.
Lost. Next day, lost.
When you file this application? When they have
But on
filed?
the same day, 22nd April, impugned order, same day this application was filed.
25.
22nd April.
25.
But if I may give in just 2 minutes to give the background of this order, my lord.
Also, if I don't see the second paragraph.
Yes, I will come to you. I come to you. No problem. Yes, your objection has been taken down by the London judge.
But kindly consider this situation. My lord, I am a tenant from 1948
Correct.
in these premises. They
Yes.
tried to build a staircase through my tenant. That was the main issue in the suit. I filed the my lord, suit for declaration of my tenancy and injunction. In 2019, I got an ad interim ex parte order of injunction. Thereafter, there was contest on the injunction. Absolute, the injunction order was made absolute. They were prevented from making the staircase, my lord, on contest. Then, my lord, they filed an application under order 39 rule 4 for modification of that order to allow them to make the staircase. That is also rejected by the court in 20th February, my lord. Then, my lord, they filed an application for advocate commissioner to take inspection of the premises. Now, my lord, that application dated 12th March 2023. Under that, an advocate commissioner was appointed, inspection took place, hearing was fixed for taking on record the report of the advocate commissioner for consideration of that.
Yes.
There was no prayer for building staircase.
Yes.
On that very same day, 22nd April, they filed an application under 151 now for
Hmm.
building the staircase through
Yes.
my tenanted premises.
Mm.
Without my considering my objections, my
Hmm.
lord,
Hmm.
giving me opportunity to file a written objection to that. Now, my lord, under order 39 rule 4, the law is very clear. Only if there is changed circumstances,
Hmm.
once an injunction is granted after contest, it can be modified.
Hmm.
Now, where modification is also rejected, under 151, that order is granted. And in effect, my lord, the suit is decreed because nothing less remains in the suit.
That is the report of the commissioner.
My lord, the report of the commissioner, kindly sees once, it is at page 90 of my petition.
90.
Yes, my lord. Now, my lord, kindly takes paragraph 5, the findings.
Yes. You have
My
filed,
lord,
you have taken the exception to the report.
yes, my lord, the hearing was for taking the exception. Now,
So-
my lord, kindly consider this D. There are two staircases.
No, no,
One is,
where is your exception to the report? Have you
my
filed?
lord, there was verbal exception taken.
Hmm.
My lord, no written exception was, my lord, taken on that date. But
Correct.
my lord, this application was filed on the very same day and it
Correct.
was allowed for construction. My lord,
Correct.
kindly consider only this paragraph D of the under para 5, the finding. There are two staircases to the
Paragraph,
first floor. From 1948 he is using. I am
paragraph,
there from 1948. My lord, subparagraph D under para 5 of the report.
yes.
There are two other staircases. One is in dilapidated condition because he has not repaired it. Defendant himself has not repaired. Second, my lord, there is a plywood sheet blocking it. My lord, it says permanently. How can, my lord, plywood be permanent? And
So-
who is accessing it? His own brother, who is the neighbor.
If you taking the plea that the plywood blockage is not a permanently, who has put the plywood?
By
Who-
his neighbor, who is his own brother. My lord, this is an internal, my lord, their dispute between brothers. I am the tenant,
Hmm.
but I have the tenancy from their
And
father.
who is the plaintiff?
My lord, plaintiff is the, my lord, tenant of the ground floor.
You are the tenant, correct?
Yes, my lord.
Who
Yes,
are
my lord.
the defendant? Who is the defendant?
My lord, defendant is one of my landlord
He
who is trying to block.
He is one of the landlord.
One
He,
of the landlord, the
Okay.
landlord. Yes, my
if
lord.
this order passed by the learned judge is modified to the extent the staircase be constructed in presence of the commissioners to show that your business shall not be hampered. You
My
are,
lord, because what is happening now is it is going through my tenanted premises. If he
But
does
you are-
it a little away, then I have no objection.
your apprehension that your tenancy premises will be affected.
Yes,
Correct.
my lord.
So
Yes,
now
my lord.
on this,
Yes, my lord. That is my apprehension. That is my apprehension. Absolutely.
the staircase may be constructed by the defendant by taking in presence of the commissioner, and your tenancy premises shall not be affected in any way.
I am obliged, my lord. If it is not through my tenanted premises, I have no objection, my lord.
Staircase has already been constructed and compliance report I have filed on 19/6,
Hmm.
my lord.
Where is that?
My lord, the compliance report I have filed before the trial court, my lord.
When the order was passed?
I know the-
19 July, 19 June. 19 June.
22nd April, the order was passed on.
Oh,
On 19th July, they have to file
the compliance report then. So if they are already constructed the staircase, what remains? What remains?
My lord, whether that is going through my tenanted, because I am, my lord, because it is going through my tenanted premises. Let him do it anywhere else.
That will be a fresh cause of action. You take appropriate steps.
My lord, kindly gives me that liberty that if it is going through the tenant, I will be able
Suffering for the
to take my necessary remedies.
of the respondent, opposite party. The plaintiff petitioner has filed the present application challenging the order passed by the Leonard Joint Civil Justice Division at Port Blair, dated 22nd April 2025, wherein the Leonard judge has allowed the defendant to make construction of a staircase in the tenanted premises within 3 months from the date of this order, with the condition that it covers only considerable area and not to hamper and tamper the business, including access to the tenanted premises. Full stop. Mr. Rohit Das, learned advocate appearing for the petitioner, submits that the learned judge has passed the order without giving an opportunity of hearing. He submits that on 22nd of April 2025, the matter was fixed before the learned court for clarification and acceptance of the report submitted by the commission. And on the same day, the defendant had filed an application under section 151 of the CPC, praying for allowing the defendant to construct the staircase as per the report submitted by the commission. Learned counsel for the petitioner submits that if if the defendant is allowed to construct the staircase, comma, the tenanted premises of the plaintiff of the petitioner and the business of the petitioner will be badly hampered. Full stop. Per contra, Ms. Babita Das, learned advocate appearing for the opposite party defendant, submits that the order was passed by the learned judge on 22nd of April 2025. And as per the said order, the compliance report is to be filed by 19th of June 2025. And accordingly, in compliance of the order dated 22nd April 2025, the defendant had already constructed the staircase, and she submits that the staircase has been constructed in terms of the order passed by the learned judge, which and in compliance of the and in terms of the commissioner report. She submits that the staircase constructed by the defendant will not in any way restrict or harm the defendant and harm the plaintiff for his tenanted premises or his business. Full stop. Heard the learned counsel for the respective parties peruse the impinging order dated 22nd of April 2025 and the report of the learned commissioner. Before filing an application under section 151 of the CPC, the defendant had filed an application for appointment of commissioner. The commissioner has submitted the report on 24th of July 2024, wherein the finding of the learned commissioner reads as follows. Set out page 92. On receipt of the report of the commissioner, the defendant has filed an application under section 151 of the CPC, praying for construction of the staircase as per the report of the commissioner. And the learned judge, considering the report, has allowed the petition filed by the defendant for construction of the staircase. This court find that in the impugn order, the learned Joint Civil Judge Senior Division has categorically held that the construction of the staircase only will be only considerable area and will not hamper and temper the business, including the access to the tenanted premises. And in compliance of the order passed by the learned judge, the defendant has already constructed the staircase and has filed the report before the learned Joint Civil Judge Senior Division on 19th of June 2025. Considering the above, this court found that nothing remains in the civil divisional application prepared by the petitioner. However, the petitioner will be at liberty if in future the petitioner will find that due to the staircase constructed by the defendant will hamper and temper the access and the business of the defendant in future, the defendant will take appropriate steps with law. C on number census disposed.
Deeply obliged, my lord. Deeply obliged.
Next. Item number
7.
Item number 6 is disposed of. Yes, 7. Who is your senior?
Asking for respect of country. So we'll be filing a Wakalatnam on the next day.
Wakalatnam on behalf of opposite party.
My senior press for the
Yes. Where is the impugn order?
case for speedy disposal.
Speedy disposal.
Speedy disposal. And there are also a direction was given,
Hmm.
saying was expired. Long back.
Expedite the TS number 1/2017. Find the same on day-to-day basis without allowing the adjournment. Where is the earlier order? You are not having the copy.
I have annexed the form.
You are not.
Just not.
Within 6 months, 2026 months, now 2025. Then what will happen? Again, the order is passed, direction is passed upon the learned judge. What is the stage of the suit now?
Plaintiff side surrender.
It is going on.
Going on.
What the bailable warrant against the witness? Tahsildar is not coming.
5 to 6 times he received the summons.
Hmm.
After it, he has not done.
How many witness you are having? After Tahsildar, you are having any other witness? No. You will be closed. Your witness will be closed. How many witness you will add? Huh? 2 witness. When is the next date fixed? Why? It is the innocuous prayer for disposal of the suit.
17/7 is the next.
You are appearing for the defendant in the lower court. You are appearing for the defendant in the before the civil judge. 5th of June. So what has happened on 5th of June? Tahsildar appeared. Then
Again, a date has given 17/7.
17 July. Year of WA. So appearing for the petitioner. So appearing for the opposite party. The petitioner being the plaintiff in title suit number 108 of 2017 pending before the London Civil Judge Senior Division at Fort Blair had filed the present application praying for a direction upon the London Civil Judge Senior Division for disposal of the case and disposal of the suit in the time frame manner within a specific time. Full stop. And counsel for the petitioner submits that on the earlier occasion also the plaintiff had filed an application before this court being CO number 005 of 2020 praying for expeditious disposal of the suit, and by an order dated 17th of January 2020 this court has disposed of the said application by requesting the London Civil Judge Senior Division to dispose of the suit within a period of 6 months from the date of communication of the order without granting any unnecessary adjournment. Counsel for the plaintiff submit that in spite of the direction passed by this court, the suit has not yet been disposed of. She submits that the plaintiff intend to examine the Tahsildar, which Tahsildar Little Andamar, and petition the plaintiff has taken several steps for issuance of summon upon the Tahsildar for appearance as witness. But in spite of receipt of the summon, the Tahsildar has not appeared, and the Learned Court has issued the warrant against the witness. But in spite of the warrant, the Tahsildar is not appearing. Full stop. Learned full stop. Counsel for the plaintiff submit that the suit is pending since the year 2017 and prays for expeditious and prays for an order for expeditious dispute. Per contra, Learned Advocate, what is your good name? What is your good name? So and so, appearing for the defendant, opposite party, submits that prays for time on the ground that his senior is not in position to appear before this court due to some personal difficulties. This court find that the petitioner has filed the present application praying for a direction of expeditious disposal of the suit. This, on earlier occasion also, this court has directed the learned judge for disposal of the case within a period of 6 months from the date of communication of the order, but 5 years has been passed from the date of the order, but till date that suit has not been disposed. This court also find that the Tahsildar is not appearing in spite of the warrant issued by the court as witness on behalf of the plaintiff. Considering the above, the application filed by the petitioner is disposed of by directing the learned Civil Judge Senior Division at Port Blair to dispose of the suit within a period of 6 months from the date of communication of this order. Communication of the order without granting any unnecessary adjournment. Full stop. This court finds that the Tehsildar is not appearing in spite of receipt of the summons and warrant, and even after warrant issuance of warrant of arrest. Full stop. The Deputy Commissioner is directed to take appropriate action against the Tehsildar Little Andaman. Why he is not appearing before the learned court in spite of the receipt of summons and in spite of issuance of the warrant of arrest, and to take appropriate action against the Tehsildar for not appearing before the court in spite of the receipt of summons. By the above observation, CO number 7 is disposed of.
Okay.
Yes. Who is appearing? Devnath Ganguly. Not today.
Time for the administration.
Item 9. Who is for the petitioner?
Well, Mr. Kishore Datta appears for the petitioner general.
Kishore Datta appearing for the petition.
My lord,
Advocate General.
my lord.
What is the matter about?
But this is, my lord, some internal mishap happened in the cooperative bank. The inquiry has been, my lord, done by the administration.
So this is regarding cooperative bank.
My lord,
They connected with the cooperating. I am releasing the matter.
my.
Due to some personal reason, the matter is released from the list of this court. Liberty to mention before the and let the matter appear before the honorable court number 1. Next. Item.
Your Lordship, in this item, is now is appearing for the petitioner general. I pray for matter may be fixed on day after tomorrow.
Yes.
But I am only for labor department. Main party is APWD.
What is the prayer?
But the prayer is to send the matter to the, refer the matter to labor court, my lord.
Refer the matter to the labor court.
Since conciliation proceeding has been
Conciliation failed.
initiated, it failed.
Ah.
So, my lord, they want the matter to go before the labor.
So why the administration has not issued the notification for sending the matter to the labor court under section 12?
I think they are, my lord, the reason is, my lord, they are, my lord, contract, the third party employees, my lord, farm contract employees. That's why, my lord.
Okay. Who is for the APWD?
APWD, my lord.
Yes, what is the submission?
Your Lordship, serve to the,
Where is the affidavit of service?
Your Lordship, I pray for time, Your Lordship.
Not today.
Your Lordship.
Not today.
Let the matter be fixed on-
Come tomorrow. Today after tomorrow.
I am for respond number 1.
Release. They want implementation.
Which one?
That's Shakti Way. Now the private respondent in that appeal have filed an application seeking implementation. So my lord cannot, this let us go to the next appeal. Because along with
I am
that-
releasing it.
But because division matter has taken the matter to the next circuit.
Okay.
That,
So connected with that.
yes, same. Report dismissed by repetition.
Mr. KMB Japal and advocate appearing for the petitioner submit that this matter is connected with the appeal. Appeal in connection with MAT number.
I'm just giving, just. Just one, just. Mat 31 of 2025.
31 of 2025, which this court has already fixed the matter before which this court has fixed the matter before the next circuit bench, and accordingly he prays for adjournment and prays for placing this matter before the next circuit bench. In view of the submission made by the counsel for the petitioner, let the matter appear before the next circuit.
Sure.
Yes, next.
I'm for the respondent.
Who is for the petitioner? Mr. Goldar. What is the prayer? Issue license to the petitioner, practice as a notary.
Notary.
Who is the
In
petitioner?
Nicobar district.
Who is the petitioner? Shoini Roy. Advocate
Mine.
of this bar. They have not given the description in the Ross title. Not today. Come after lunch. Other matters after lunch. 2:15.
It's not Monday because
14.
14, 1.
When I will take the matter, mention someone junior.
But I am for petition.
Yes.
Whether it's the daily and electricity.
Mm.
It's not an, stress is a very for the responsibility.
Where is the affidavit? Has he filed the affidavit?
Pay for not. I'm not. We are also in this matter, not appearing for the private respondents.
Mm.
That is just for filing AO your
Mm.
required some more time.
Why? The matter is.
The lordship respondents residing in their annexes. Bad as a condition. The 6.10.
The matter is pending since the March 2025, not March, January 2025.
Let this matter be fixed.
No, I will not grant. Can come, not today.
13 to 16 matters discussed are very.
Tell Misra, if tomorrow he will not appear, I will pass appropriate order. 13 to 16, not today.
14.
Hmm. What?
On last day.
Come tomorrow. Yes, next. Give.
This matter, my lord, actually, there was some issue, my lord, but it is being sorted out, my lord. So, Mr. Kumar had also indicated, my lord, that we will not be averse to a matter getting adjourned, matter. But let it go to the next.
Why? Contempt petition.
No, order is, my lord, order has been in a sense complied with. There is one offending portion in the, there is a, because my lord, that 1/30 benefit was to be given. While giving the 1/30 benefit, there is a clause saying that this will not give right to any future regularization. So that was the petitioner was offended by that. But that, my lord, it is in the process of being amended and that will be struck or deleted, my lord. So therefore, my lord.
Let it be fixed in the next one.
So offering for the petitioner, so offering for the alleged contemner. It is submitted by both the parties. The alleged contemner has complied with the order, but one portion is required to be complied with, and as such, they press for time. Accordingly, the case, as per the submission made by the counsel for the parties, the case is adjourned. Let the matter appear before the next circuit. The alleged contemner directed to file the affidavit of compliance on the next date. Yes. Next.
19,
Last time, my lord, the time for reply was sought by Mr. Prashad, but he not yet to tell everything of.
6 to find reply.
Contempt is alleged of order passed by the district judge, my lord. According to us, we have complied, but.
What is the order?
The order was to hand back possession, my lord. Possession has been handed back, but Mr. Prashant was alleging that for a particular duration, my lord, he agreed by the fact that.
Come tomorrow? Not today.
Extension of and compiling
Affidavit in opposition, it is filed. Who has filed?
it can be off. Can happen.
Where is the can? Amendment of affidavit in reply to the petitioner. Affidavit opposition of the respondent. What's it? Yes, on the last occasion also you have taken time, madam. What has happened within 1 month? You're not done so. So and so appearing for the petitioner, so and so appearing for the respondent. Counsel for the respondent prays for extension of time to file affidavit in opposition in connection with can number 2 of 2020. Can number 1 or 2? Yes. So what is 1? Where is 1? Where is 2? And what about 1? 1 is already disposed. Can 2 of 2025. Let affidavit in opposition be filed within a week. A reply, if any, there to be filed within a week thereafter. Placed before the next circuit bench. Next.
But in 23, we want video 23.
21? 2nd July, yes.
My lord, order of the labor court, my lord.
Why all Monday? What will do this court with this week?
Let it be, my lord, on Thursday, my lord.
Labor court order? What is the claim?
They are seeking reinstatement.
Retrenchment of the workman second part is not hit by section 25F. So and so appearing for the petitioner. So and so appearing for the respondent. Counsel for the parties raised for time. According to Sir John, let the matter appear on 3rd July. Next.
Four, W 25, W 3, 4.
Your lordship, in this matter, Mrs. Mali is appearing for the petitioner petition. Let the matter may be fixed on day after tomorrow.
Who is for the respondent? Affidavits completed?
Yes, my lord. And the Ministry of Shipping is also made a party, my lord. So one was obtained.
As per the prayer made by the counsel for the parties, let the matter appear on 2nd July. Next.
You are one of 23.
Who is for the petitioner? Neither petition nor state. I am disposing on merit. If nobody is appearing, take dictation. Nobody is there. Let the matter appear tomorrow at the top under the heading specially fixed matter. Tell the bar, from tomorrow no adjournment will be granted in my court. You are playing with the court. Tomorrow, all matter tomorrow if nobody, and I will not grant adjournment from tomorrow onwards. Next. If your senior is not able to come this court, you come ready. If you are asking the adjournment. Yes.
By ATA mediation file affidavit in reply in respect of respondent number 1 and 2. They have filed the affidavit in opposition.
Who is for the respondent?
Private respondent. For private respondent, they have already filed. I have filed the reply.
Not today.
Share has sought time to file reply.
Reply. Reply by petitioner.
Try to.
You are paying for whom? Who is for the petitioner?
Rakesh Pantu.
None appears on behalf of the petitioner. Mr. Leonard Senior Advocate, Mr. Saptadru is appearing for the all authorities.
Yes.
All the respondents. Let the matter appear tomorrow. Next.
21, 54 of the report, 2022, is the final of the report.
Already item number 37 is senior respondent. Item number 37 is senior president.
Who is for the petition appellant?
I have the direction for filing supplement whips. I'm seeking 1 week extension.
Supplementary paper will be filed by the respondent in essay number 4 within a week. 19 June, within a week. As per the prayer made by the counsel for the appellant in essay 4 of 2024, time to file supplementary paper book is extended for a further period of 1 week from date. List the matter on 8th of July, 9th of July 2025. Next.
34, it's a line of the report.
What has happened? 33? Huh?
Your actually is not very important.
Ready?
For other side,
You start. Other side I will see. You start.
let us say a feature of your.
Not today. Next.
The 34 is the line of the report.
Your worship, in this matter, Mrs. Nand is appearing for the petition of your worship. I pray for time.
Not today.
We are in the report.
My lord, from item 35 to 38, connected matters. As President Muhammad Yunus appeared for the petition, my lord, he is not in station. He went to parent for next circuit.
When he will back?
He has not tell the exact date, my lord. Maybe.
I am keeping on Friday. You take the instruction.
In that case, maybe next week.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 7th July. 35 to 38, huh?
in 39, 84, 24.
39 cannot, we have a response number 1.
Yes.
In opposition, I have.
Respond number 2 file reply.
What a municipal.
Reply or affidavit. Yes.
You can, based on written, like, place it, or should let it come tomorrow. On place of, based on.
Not today.
I can start, I can start, I can, not sure, I can start.
Come to. Not today. Next.
41, our 9,024.
Yes.
My lord, my lord, in this case, my lord, during the pendency of the dispute, my lord, so the scheme has been promulgated by the administration, where, my lord, this this is a case where, my lord, where it's an industrial estate matter, my lord, where some violations were, according to us, they violated the terms of the lease. Now subsequently, there is a scheme whereby these things are being regularized subject to payment of certain penalty. And not this matter, my lord, was taken up in earlier occasion where, my lord, the matter was adjourned for consideration of their application under the scheme. My lord, that if my lord may just keep it for tomorrow, my lord, I will find out the status, my lord, and inform the court what is the status of the consideration of their application under the scheme.
Let the matter, as per the prayer made by the counsel for the respondent, let the matter appear on 3rd. Next.
Response number 123.
Yes.
Should I want to
Appearing for the respond number 4 and 5. Who is appearing for the 4 and 5? Where is your affidavit officer?
5 days time.
5 days time.
Next week, I will.
Then he will file reply.
Just 2 days thereafter, not, I will not reply, use reply.
Let the affidavit come first.
That's from.
So and so appearing for the petitioner. So and so appearing for the respond number 1, 2 and 3. And so appearing for the respond number 4 and 5. Counsel for the respond number 4 and 5 prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 7th July. List the matter on 8th July.
Well,
Your Lordship, in this matter, now is appearing for required 1 week of time to filing reply.
Reply? What reply? Affidavit in opposition, what reply? They have disclosed any new document? Affidavit in opposition in Excel. 11 June you have taken time, madam. A week period, 2 weeks time. Who is for the respondent? Counsel for the petitioner. Prays for time to file affidavit in reply. Let affidavit in reply be filed by 8th of July 2025. Let the matter appear on 9th of July 2025. Next.
44, number 224, 2024.
As the suspension, as the direction of this conference, they have made the necessary amendment in hospital and we have said that the of reparation.
To who? Where is affidavit, sir? Sir, no, sir. Irshad Ali. Have you sent? Counsel for the petitioner submits that the petitioner has sent the copy of the amended writ application to the added respondents, but she has not received the track report and prays for a week time to file affidavit of service. Let the matter appear on 7th July. Next.
45, I will be 51 for the report.
She might see appears for the respondent.
Mm.
She appears for the petition. Just one.
Not today.
See, the report is 5 of the report, 2047, the report is 6 of the report.
I'm for respondent.
Who is for the petitioner? Mr. Prashant? Not today. Next.
In 48, the report 96 of the report.
This is not electricity matter. Who is appearing? None appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, the case is adjourned. This court finds that this matter is connected with the grant of electricity connection. List the matter under the heading electricity matters. Tomorrow. Tomorrow. Next.
49, I will file one piece of the report, that is 50, I will file one paper of the report.
These bunches of matter can be taken up on this side.
Next circuit.
These are the.
You has been filed.
You have filed. Reply.
Please reply, Your Worship. You purely question of law, there are some facts, mainly purely question of law has been raised, Your Worship.
When?
But I will not be needed. Yeah.
Counsel for the parties submit that. The matter is ready for hearing. Let the matter appear on 2nd July.
Great.
Yeah. Hearing है ना heading में
हाँ.
अंडर द हेडिंग हियरिंग कर कोई हियरिंग कोई आप लोग कोई हेडिंग नहीं रहता हियरिंग है ठीक है यस नेक्स्ट Yes. Yes. Affidavits completed. Affidavit within 2 weeks, reply within 1 week.
The wedding pilot.
Counsel for the respondents press for time to file affidavit and press for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter before the next circuit. Next. Yes.
Regard to the both the melod, after HST and both will be applicable or not.
You are for the appellant. Who?
The court has, Supreme Court has asked me. Even last time the case, for the district court has been treated as a suit, like a money suit.
Which matter? MSCT. MSCT case is to be treated as a money suit. Who has given the advice to you?
Yes, sir, because I have.
No. Who has given the advice to you? The MSCT case is to be treated as a money suit?
Yes, because it is a claim.
Claim of compensation under the special act. It is not a borrowed or lent in advance. So how it is a money suit? It is a beneficiary legislation. Then
What's why communicating to them? Yeah,
what has happened? What is the
just fix it for only on this.
what the district judge has passed an order for payment of court fee on the compensation amount? Who has filed this?
Your Worship, this is not again.
What is your contention?
Your Worship, I prayed for a day of.
What is your contention? I am asking. You are the junior.
Yes,
You might have been drafted or you have gone through the pleadings. No. What you are doing in the chamber? What you doing in the chamber? Only the senior telling go and take the adjournment, taking adjournment. Not today. Next.
58, 54, 55.
Yes, Mr. Chakravarti, you also see in the MSCT matter whether it is a beneficiary legislation, either 166, 163. If the court has passed an award, whether the court fee is required to be paid by the petitioner who is a legal heir of or the deceased or the victim. You would see address on that. Huh? See, tomorrow if required, then I will tell.
Actually, this practice of treating it as a money claim matter is being done by the registry of the district court.
No, I don't find Mr. Japan knows better than us. No, it is money suit. The money suit head is totally different in the district judiciary. Money suit head is the total different. The title suit is totally different. The other suit is totally different. And this, the MSCT cases are the other things. It will come under the miscellaneous.
It's tribunal.
It's a tribunal. So how the tribunal can say the court fee is to be paid?
I don't imagine we'll also examine.
Because we go by that arbitration.
Yes.
Arbitrator pass an award.
Yes.
He cannot say the 30 crore you pay the court fee and the award will be passed.
Right.
Only 100 rupees bond paper supplied by both the parties, award is passed. Challenging that you can pay the court fee in the court.
The time of
Execution. This please see to that.
Yes, sir.
Yes.
Yeah, yes, but.
58.
I'm there for the employee.
Who is your senior? Yes. Yes, Mr. Japal, what is the matter?
What has happened, Lord? I have a property at Bangalore. It's duly recorded in my name. The airport authority invoked the Airport Authorities Act, saying that land to be the airport's authority land, and issued a notice and passed an order which I challenged. I have obtained an information from the Tahsildar office. The land for which the eviction order has been passed, it's a government revenue land. So my contention is, it's without jurisdiction. At best, 202 not goes 202 proceeding by 30, it's a revenue land. How an airport authority can invoke the
It is not allotted to the airport authority?
No, it's revenue land. It's purely revenue land. I brought the documents part of the petition.
So they pass, who passed the order?
Airport authority,
Airport authority who? What is the designation?
eviction officer. Eviction officer.
Under which law?
Under the
Airport Act.
Yes. It's not a airport premises. The Act defines airport premises. It's something like PP Act 1970. Public Premises Act.
Correct. Yes.
But some things were not.
Reading completed. Reading
It's an appeal, not so there's a direction for opposition. It's an appeal, not safe. So we can.
Okay. Next, sir. Not today.
Great.
59, that would be clear.
Yes, it's the same.
So not today.
61, you are going to wait for 25.
I am for the responded state laws. For washing of paper and entire cognizance under PAT regulation, charge sheet was filed.
Why it should not be caused?
Lordship, 8B was, FIR was lost for
এটা কি?
promoting some commercial activities
এটা
of
কি?
their worker.
হ্যাঁ?
Eight B Lordship,
Ah.
charge sheet was filed. He has circulated some pictures, videos of Java tribal to his own channel. That's so for
Acha,
that
sir.
reason, charge sheet was filed, FIR stopped out. They have challenged that charge sheet, the entire FIR will be. Last order we received also that petitioner was directed to serve a copy without that photographs, annexing the photographs.
Not served.
Not served. What is the position? I don't know. Deep Kabir is there.
Not really.
Also.
Next.
Again, it's 150 or 125.
What is the case? Readings completed? No. Respondents be extended for the period. Extension has been given. Application filed. How soon? So applying for the counsel for the petitioner pays for time to file affidavit. Where is your opposition? Wait for time to file affidavit in reply. Let affidavit in reply be filed 2 weeks. This is the matter before the next circuit. Next. File reply affidavit.
Some similar matters are.
Where?
Nepal directly was a matter.
So let it be go to the court.
I'll get it delisted from.
Yes, sir.
Senior.
Municipal matter lot, no, it's not much, it's one and same. One and same lots, not single matter is one and same. But as not.
Record an order 64, 65, 63, 64, 65. Counsel for the petition submitted. Press for fixing the matter to some other date. In view of the above, let the matter appear on 4th July. Next.
I'm there for me.
Have already filed the opposition in the registry.
Have you received? Send the copy. Opposition come. You will file reply, Mr. Jaipal. Counsel for the respondent file affidavit in opposition after serving the copy to the learned counsel for the petitioner. Let the same be kept with the record. Counsel for the petitioner press for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. This is the matter before the next circuit.
With the interim order which is get operative till end of July, because the next circuit start at
28
of July. Not getting be extended in August.
No, 28 the next circuit.
There was first day normally not knows. I think Friday not something was
On
wrong.
the this is the matter on the second day of the next circuit bench. Liberty of the
Order dated 10th June 2025. They kind
which
10th
portion?
June 2025.
Yes, which portion? I direct the impugned order
But for last
till 30th June. Till 30th June.
July no.
Straight.
June 2025 order. It's up till July 2025. Till the end of
Which
July.
paragraph? Which paragraph?
Last but one paragraph, on the third paragraph. Order dated 10th June 2025.
Acha, 10th June 2025. Till the end of July 2025. When the circuit starts?
28th of
Answer me.
no.
Huh? Next circuit. So on first day it will come, Mr. Japal will mention for extension of time.
I said, 57, now we want to 0.25.
I have already filed my opposition.
Same order.
Same. This has to be delisted from my office. Because three matters are before court number one, and the special officer, Mr. Lokesh was appointed. So let us start to delist. So I can imagine.
Counsel for the petitioner submit that the analogous matter is appearing before the honorable court number one. Accordingly, the matter is released from this the list of this court, liberty to mention before the honorable court number one. Next.
I think 59, now we want, I file of 125.
I am appearing for respond number 1 and 2, my lord.
Yes, so
We
is the
have filed
petition.
our opposition.
Lokesh Chase.
Mr. Chakravarti, you are appearing for? 3, 2. 1 and 2.
No, 1 and 2 I am appearing, my lord.
3
3 are appearing.
3, 2 they are appearing.
Affidavits filed.
1 and 2 I have filed. On 21st May I have filed in
Yes,
the
1 and 2 filed. Where is the affidavit of opposition of 3?
we have not filed.
So 1 to 5.
Yes.
Counsel for the respondent number 3 prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Before list the matter before with the next circuit.
1 and 2 file that may be recorded.
Already there.
Already. Obliged, my lord.
Next.
I think 70, now it will be a war of 125.
I'm for the responding unit. I have filed my affidavit in opposition before the registry. It's
Where is Mr. Jaipal? Reply.
serving copy to the registry.
I'll use my reply.
Okay. Ms. Bhavita Das, learned advocate, appearing for the respondent, file affidavit in opposition after serving the copy to the learned counsel for the petitioner. Mr. Jaipal, appearing for the petitioner, prays for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks, placed before the next circuit bench.
Obliged.
Next.
In 71, now it will not be from 125.
None appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, the case is adjourned. Let the matter appear on 4th April. 4th July.
We have filed.
Item 72.
Now it will 8 of 125.
My lord, in item number 72 to 74, I'm seeking extension of time to file our reply.
You file the affidavit opposite?
Yes.
Earlier occasion you has taken time. Affidavit in reply to the affidavit in opposition, 2 weeks. Learned advocate appearing for the petitioner prays for extension of time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks, placed before the next circuit.
Same in my lord 73 and 74.
74.
Same, 73, 74. Next.
75, everything, 4 for 125.
And for this.
Affidavit filed.
No, nothing.
Bhavita Das.
My lord,
Affidavit within 2 weeks.
I will be appearing, my lord.
Hearing.
I seek extension
in
of.
this matter, due to some personal difficulty, my lord, since I
You
have.
are appearing.
I am appearing.
You file affidavit.
I am seeking extension of time.
Mr. V.D. Sivalan, an advocate appearing for the respondent, prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter, placed before the next circuit bench.
Obliged, my lord.
Item 76, February 2/6/5/45.
My lord, I'm appearing on behalf of respondent number 1 to 4, my lord. I will be seeking extension for filing my opposition, my lord. This is the first extension.
Ms. Babita Das, an advocate appearing for the respondent number
1 to 4.
1 to 4. Prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, they are to be filed within a week thereafter, placed before the next circuit bench.
Obliged.
Next.
Item 77, February 2/6/2025.
And for the respondent.
Who is for the petitioner?
Mr. Ajit Prasad. My lord,
Due to personal
my lord,
reason?
I'm seeking time for extension filing.
Due to personal reason, the matter is released from the list of this court with the liberty to mention before the court, honorable court.
Obliged.
You want to put them?
What?